Previously, Mr. Edwards has been paying 2,300 a month, correct?
Yes, sir.
So the proposed reduction, do you think you'll be able to maintain the children's needs with that amount?
Their basic needs, possibly. It would be a very big burden on myself. I'm a school teacher and I make very much less per year than he is capable of. I feel like doing this to them after their entire lives, having a lifestyle that met the lifestyle we had when we were married, would be detrimental to them and their future.
Dad retires and files for a reduction in his child support obligation.
And it's in the interest of Kieran and Cameron Edwards. The state filed a motion to adjust the child support Mr. Edwards is paying to Miss Langley.
That's correct, Your Honor. At this time, the state will call Mr. Edwards. At the time when the previous order was done, were you previously ordered to pay $2,300 a month in child support?
Yes, sir.
And is that for your two children that's before the court today?
Yes, sir.
And at that time, what kind of work were you doing when you were ordered to pay that the $2,300 a month?
I was a U.S. Border Patrol agent with Customs and Border Protection.
And have there been any changes in your job since the time of that previous order?
Yes, sir. I retired at the end of December.
And what are you making now that you are retired?
My monthly income will be, $4,459.
Is that before taxes or after taxes?
After taxes, sir.
What is your income before taxes are taken out? What's your monthly gross income?
So gross prior to insurance and everything, or just taxes?
Yes, sir. Just prior to insurance and prior to taxes.
It is $5,976.
Do you have any other minor biological children who are below the age of 18?
I do not.
Do you have health insurance available to you that is affordable?
I do.
And what would the cost be to put your children on your health insurance? And is this health insurance through your employer?
It is, yes, sir. And the cost, my total premium is $664 per month. The cost, and that covers 4 people. The cost for the children would be half of that, which is $332 per month.
$332 for health. And do you also have dental insurance?
I do, sir.
And what is the monthly cost for dental insurance for your children?
Total of $184, so half would be, I believe, $92 per month.
Are you asking the court today to modify your child support to be based on the guidelines based on your current income that you get from your retirement?
That is correct, sir.
And do you have any other sources of income besides your current retirement income of $5,976 a month?
I do not at this time.
I have no further questions. I pass the witness.
Your witness, Mr. Eli.
Thank you, Your Honor. So your retirement was effective, was it December 31st?
December 30th.
December 30th. Okay.
Yes, sir.
And how long had you been with, I guess, the Border Patrol prior to retirement?
20 years and approximately 6 months.
Okay. So that's considered a voluntary retirement?
It is, sir. Yes.
Did the eligibility for retirement kick in at 20 years?
It did. Once I reached 50 years old and 20 years of service.
Okay. So are you currently 50 years old?
I am, sir.
Okay.
All right, guys. This courtroom battle begins with a major financial dispute that could dramatically reshape 2 children's future. A father who has faithfully paid $2,300 every month in child support is now asking the court for a substantial reduction after retiring from federal service. The children's mother argues that such a cut would place an enormous burden on her shoulders as a school teacher and force the children to abandon the stable lifestyle they have always known. From the very beginning, emotions and financial realities collide inside the courtroom. As the hearing officially gets underway, the state calls the father to testify and reviews the existing child support order. He confirms that he has been paying $2,300 each month for his 2 children under a previous court ruling. He explains that when the original order was entered, he served as a United States Border Patrol agent with Customs and Border Protection. However, everything changed after he officially retired at the end of December, leading him to request that the court recalculate support using his new retirement income. The testimony then shifts toward the father's current financial situation. He tells the court that his retirement now provides a significantly lower monthly income than his previous salary. He also confirms that he has no additional children to support and continues providing health and dental insurance for both children through his retirement benefits. Detailed figures for insurance premiums are presented to the court, demonstrating that he remains responsible for substantial monthly health care costs despite leaving federal employment and beginning a completely different financial chapter. The cross-examination quickly becomes more intense as opposing counsel focuses on whether this retirement was truly unavoidable. The father acknowledges serving more than 20 years before voluntarily retiring once he became eligible. Although legally entitled to retire, the attorney questions whether stepping away from full-time employment has unnecessarily reduced the financial resources available to his children. The courtroom atmosphere grows noticeably more serious as the discussion shifts from simple income calculations to the broader question of parental responsibility after retirement.
Now you have two children that you pay support for, correct?
Correct.
Is it true currently you pay $2,300 a month?
That is correct. Yes.
Okay. And is it true the amount that that was calculated and was put into the Attorney General's paperwork was about $1,100?
Yes, I believe it was 1104 something, but near 1100. Yes, sir.
Okay, so would you agree with me? That's a little bit more than a 50% reduction.
It is a reduction. Yes, sir.
So prior to retirement was your only source of income through your employment with the Border Patrol?
Yes, it is. Yes, it was.
Okay. And that's your testimony now, is that you have no other sources of income?
That is correct.
Are you looking at taking a post-retirement job or anything like that?
I'm unsure at this point. I mean, I'm not opposed to it, but I don't know what's available or what might come available. So at this time, I am not actively in search of a job.
So, and I'll come back to that, I guess, line of question in a minute, but let me ask you this. Do you have any interest income from any sources?
No.
Do you receive any dividend income?
No.
Do you receive any royalty income?
No.
Do you receive any kind of rental income?
No.
Okay. Did you get any kind of lump sum payment upon retirement?
Yes.
And what was that?
For unused annual leave.
Okay. And how much was that payment?
Do I have to answer that question, sir?
Yes, you do.
Okay. It was approximately $25,000.
Do you receive any other retirement benefits?
No.
Okay. Do you have any other retirement accounts?
I have a 401k.
Do you draw from the 401k?
I do not.
Do you have any other pension?
I do not.
Do you have any kind of thrift savings plan?
That's my 401k is a thrift savings plan. I don't have a separate 401k.
Okay.
Sorry, I should have called it thrift savings. I didn't realize you knew the difference.
That's okay. I just wanted to verify we were talking about the same thing.
Yes, sir.
Do you receive any income from a trust?
No.
Any other type of annuity?
No.
Okay. Do you receive any kind of Social Security benefits?
No.
Have you received any unemployment benefits?
No.
Do you have a LinkedIn profile?
I do.
Okay. Is this your LinkedIn profile?
I believe so, yes.
Okay. And it lists you as a supervisory Border Patrol agent, retired U.S. Border Patrol.
Correct.
So would I be correct in saying that you recently updated this profile?
Recently, yes, sir.
Okay. And you list some of your skills here. Is that correct?
Correct.
Okay. Were these skills that you engaged in as a Border Patrol agent?
They were.
And can I ask you the purpose of updating the LinkedIn profile at this point in time?
Because I retired from the Border Patrol, and it appears from what I've been told that if I do choose to start looking for work, that's where people go to look. So as you can see, it's very incomplete and very basic because I really am not up to date with how LinkedIn worked. I've not had to look for a job in over 20 years.
Given your experience, what type of work would you be able to find with your experience?
I honestly don't know in the
All
private
right,
sector
guys, this
how.
is where the courtroom begins digging much deeper than simple retirement numbers. The attorney highlights that the father's monthly obligation could fall from roughly $2,300 to just over $1,100, a reduction exceeding 50%. While the father openly admits the decrease is significant, he insists it reflects his current financial reality rather than an attempt to avoid supporting his children. The questioning then shifts toward whether hidden income exists, setting the stage for a careful examination of every possible financial resource he might still have available. The attorney systematically works through every potential source of income one by one. Interest earnings, dividends, royalties, rental properties, pensions, trusts, unemployment benefits, and other investments are all placed under the microscope. The father repeatedly answers no, maintaining that retirement payments remain his only continuing source of income. However, one important detail immediately captures everyone's attention when he acknowledges receiving approximately $25,000 as a lump sum payment for unused annual leave upon retirement, creating another financial issue the court will later have to evaluate. But that's not the shocking part. The questioning soon turns toward the father's retirement savings and future earning potential. He explains that his federal thrift savings plan functions as his retirement account and confirms he has not withdrawn money from it. Attention then shifts to his recently updated LinkedIn profile, prompting questions about whether he is quietly preparing to return to work. The father responds honestly, explaining that he updated the profile simply because retired professionals often use LinkedIn if they eventually decide to explore employment opportunities after leaving government service. As the examination continues, the attorney presses harder, suggesting that someone with more than 2 decades of federal law enforcement experience should remain highly employable. The father, however, refuses to exaggerate his prospects, explaining that he genuinely does not know how valuable his skills may be within the private sector after spending most of his career serving as a Border Patrol instructor. With retirement documents already submitted into evidence, the courtroom prepares to shift away from employment questions and toward the children's educational needs and ongoing financial responsibilities.
Honestly, don't know in the private sector how marketable my experience would be, sir. I've been a Border Patrol instructor for 15 years prior to, or 12 years prior to coming out to the area I'm in now. So that was the majority of my career.
Now, you provided a document to the Attorney General previously, correct? That talked about your retirement income?
Correct.
Okay. And that's the document you were taking your numbers from when you testified, correct?
Correct.
Okay. And you sent that document to me today. Is that
I
correct?
did. Yes, sir.
Okay. Now, on that document, your retirement document, it comes from the who did that document come from?
It comes from the retirement group for Federal Customs and Border Protection.
So
they're called RABIS, RABIS, I believe is what I've always heard them called.
Okay. And they calculate your retirement. It's a formula, but it takes your average, your highest 3 years, correct?
Correct. Highest 3 consecutive years.
Okay. And that was, am I correct in saying that was $172,277?
That is correct.
So how old are your daughters?
They are 17 and 14.
Okay. Now let's talk about Kieran, the oldest child. Is she in a dual high school college program?
She is.
Okay. So she's not graduated from high school yet, but she's actually physically attending college.
That is correct.
Okay. And that's through Lamar University, correct?
Correct.
Do you
The
know
Texas
the name
Academy. Texas Academy at Lamar University.
Okay. Do you know what the costs associated with that are?
I do not know exactly what the costs associated are, but I know that she's paid up through the end of the semester, so she should have no more costs associated with that I know of associated with graduation.
Now, when you say paid up, are we talking about the tuition or what does that entail?
To just from what I've spoken with her, it appears that they pay it's works similar to like a college. It's tuition, lodging, food, all of that is similar to like a college program. I'm sure
Okay.
there are some costs associated with graduation, but I'm unfamiliar with those. I don't get a lot of contact with Karen, unfortunately.
Okay. What about Cameron, the 14-year-old? She's a freshman in high school, correct?
Correct.
Are there any expenses, additional expenses, kind of outside the normal, you know, typical cost of I guess, past the necessities of raising a teenager that you're aware of?
I guess it depends on the type of teenager. I know she's very active in club volleyball.
Okay.
Other than that, she's active in band at school, but she's active in school activities. I know that the thing she does the most outside of that is volleyball.
Okay. But are you aware of the costs associated with the club volleyball?
I am not.
Reducing the amount of child support you pay, I guess does it make logical sense that more costs are going to be passed on to Tara?
It makes logical cost that, yes, both I and Tara will have to make adjustments with the decrease in my salary. Yes.
Do you receive any kind of other fringe benefits? Does anybody pay for provide you with a vehicle or anything of that sort?
No, sir.
Any housing paid for or
All right,
anything like that?
guys. The hearing now shifts from the father's career to the paperwork supporting his retirement income. The attorney carefully reviews the official retirement documents, confirming they were provided before the hearing and used during the father's testimony. The father explains that the records were prepared by the Federal Retirement Administration responsible for calculating benefits for Customs and Border Protection employees. He further confirms that his retirement amount was determined using the average of his 3 highest consecutive earning years, a standard formula used throughout the federal retirement system. The focus then turns to the oldest daughter, Kieran, whose educational situation adds another layer to the case. The father explains that she is enrolled in a dual high school and college program through Lamar University while still completing high school. Although he admits he is unfamiliar with the exact expenses, he believes her tuition and related costs have already been paid through the current semester. However, he also acknowledges having limited communication with his daughter, making it difficult for him to fully understand every financial obligation connected to her education. Attention quickly shifts to the younger daughter, Cameron, who is now a freshman in high school. The father describes her as an active student involved in both school activities and competitive club volleyball. While he recognizes her commitment to the sport, he admits he does not know the exact costs associated with tournaments, travel, equipment, and team fees. The attorney argues that reducing child support could force the children's mother to shoulder even greater financial responsibilities as these extracurricular expenses continue to grow year after year. The questioning becomes even more direct as the attorney asks whether the father could return to work after retirement. He admits that finding another job remains a possibility, but says he is not actively searching at the moment. If his income increases in the future, he promises to notify the state of Texas and comply with any required child support adjustments. The attorney then explores the father's property ownership, vehicles, and lifestyle, attempting to determine whether his financial circumstances are stronger than his retirement income alone might
Housing
suggest.
paid for or anything like that?
No, sir.
So at this point in time, you say you're not actively looking, but you could go back to work.
It's a possibility, and if that happens, then I'll abide by the court rules, and I will let the state of Texas know that I'm earning more money.
Okay. Now you just is it true you purchased a new home last year?
No, I
3
purchased a
years
new
ago?
home when I moved to West Virginia 3.5 years ago.
Okay. Is that near the Potomac River?
It is.
And you own a riverfront lot there on the Potomac River?
It came with the home, yes. It's
Okay.
part of the housing development.
And you've got some you know, some toys, boats, and you have 4 vehicles. Is that correct?
It is correct. And I see what you're getting at, and I would like to respond to that.
Well, just
Okay.
right now, just answer the question that Mr. Elrod asked you. I'll give you an
Okay.
opportunity at some point in time, Mr. Edwards, to respond. Okay?
Thank you, sir.
You're welcome. Go ahead, Mr. Elrod.
Are you going to be able to maintain those obligations on your income of about 71,000 before taxes?
Yes, sir. I expect to be able to do that.
Okay. But you understand you've decreased the resources available to your children as well by retiring early,
I do realize that.
and that may have an effect on their needs and so forth.
I realize that a decrease in salary affects everyone involved. Yes, sir.
Okay. I will pass the witness at this time.
You're a witness, Mr. McMillan.
I have no further questions for Mr. Edwards at this time.
Call your next witness.
At this time, the state will call Miss Langley. Miss Langley, you heard Mr. Edwards testify that he currently has your children covered on health and dental insurance that he gets through his employer. Do you agree that your children are covered by the health and dental plans that Mr. Edwards gets from his employer?
Yes, sir.
And do you agree with the rates that he provided to the court for the cost of the monthly costs for health insurance and the monthly costs for dental insurance?
Yes, I agree.
Do you oppose reducing Mr. Edwards's monthly child support obligation?
Yes, sir.
I have no further questions. I pass the witness.
Your witness, Mr. Elrod.
Thank you, Your Honor. Previously, Mr. Edwards has been paying $2,300 a month, correct?
Yes, sir.
So the proposed reduction to $1,100 and maybe a couple dollars, do you think you'll be able to maintain the children's needs with that amount?
Their basic needs, possibly. It would be a very big burden on myself. I'm a school teacher and I make very much less per year than he is capable of.
I guess so. Let's talk about your resources. What's your job?
Mr. Elrod, I'm trying to think of what the relevancy of Mrs. Langley's income is in regards to how much child support Mr. Edwards is supposed to pay.
Your Honor, as far as just her under the additional factors that the court can consider, the respective positions of the parties to contribute to the needs of the children.
Okay.
Your Honor, if I could.
No, you can, Mr. Edwards.
I can't.
No, you can't. Do you have an objection?
All right,
Mr. Edwards?
guys. The pressure inside the courtroom rises as the attorney shifts focus from income to lifestyle. Questions begin surrounding the father's home in West Virginia, its riverfront location, the vehicles he owns, and whether those assets suggest he can comfortably afford higher child support. The father confirms owning multiple vehicles and acknowledges that the property includes riverfront land because it came with the home purchase. As he attempts to explain the circumstances behind those assets, the judge briefly interrupts, instructing him to answer only the questions being asked before offering additional explanations. The attorney continues pressing the issue, arguing that by retiring at only 50 years old, the father has voluntarily reduced the financial resources available to his children. The father does not dispute that his lower salary affects everyone involved, but he insists retirement was a legal right earned through more than 2 decades of federal service. After concluding the father's testimony, the state calls the children's mother to the witness stand, where she immediately confirms that the children remain covered under the father's health and dental insurance. Without challenging those insurance costs, the mother's testimony quickly centers on the proposed reduction in child support. She explains that cutting the monthly payment from approximately $2,300 to around $1,100 would create a significant financial burden. As a school teacher, she says her earnings are far below what the father was capable of making during his federal career. According to her, maintaining the children's established lifestyle would become much more difficult, and she believes such a dramatic reduction could negatively affect their stability, opportunities, and overall future if the court approves the requested modification. But that's where the courtroom becomes even more intense. As the attorney begins asking about the mother's income and financial resources, the father's side objects, questioning why her earnings are relevant to determining child support. The attorney argues that Texas law allows the court to consider each parent's financial position when evaluating the children's needs. The judge overrules the objection, allowing the questioning to continue. The mother then reveals that she earns approximately $4,300 per month, setting the stage for a much deeper discussion about the children's educational expenses and daily financial needs.
Do you have an objection, Mr. Edwards?
Yes, sir.
What's your objection?
My objection would be if her information is included, shouldn't her spouse's information be included as well?
Your objection is overruled, Mr. Edwards. Go ahead,
Thank you, sir.
Mr. Elrod.
And I'll make this brief, Your Honor. So you work for the school system.
Yes, sir.
What's your approximate bring home income?
Bring home $4,300 a month.
As far as the needs of the children, we already established. Do you agree with Mr. Edwards' testimony that Kieran is in a joint high school college program?
Yes, sir.
Okay. So she's not physically living at home.
She comes home on the weekends.
Okay. But she'll graduate in May. Okay. And then she'll turn 18 in June.
In June.
Okay. Now, does she have any kind of scholarship or anything like that for this program?
The way the Texas Academy works is the TEA pays for their tuition. We are responsible for room, board, books, fees. So we pay roughly $10,000 a year, $5,000 a semester for her to go to this school.
Okay. So to finish out this semester, what's the cost of that?
We're on a payment plan, and the total amount is left to pay is $2,300, and it's due by April 12th.
How often have you made some other payments recently?
Yes, sir. We paid a first payment. I don't remember exactly what. It wasn't as much because the scholarship kicks in first, and then we do the other payment. So I think the first payment was a few hundred, $400 or $500, and then this one. But it comes out like last semester we paid $5,000, and then it's a 2-year program. So we did this last year as well. It was $10,000 last year.
But she'll graduate in May. She'll turn 18 and emancipate anyway, correct?
Right. Exactly.
Okay. But I guess in the meantime, are there still some other expenses with her being out of home? Does that require her to have a vehicle and
yes, sir.
so forth?
We have a vehicle and insurance on her so she can drive back and forth every week.
Okay. Now your younger daughter, Cameron, 14 and a freshman in high school, correct?
Mm-hmm.
Okay. Mr. Edwards said she's very active in club volleyball.
Yes, sir.
Okay. How long has she been doing that?
This is her 3rd year. So since she was 12.
Okay. Is that something that's very important to her?
Yes, sir.
Okay. Are there expenses with that?
There are very, very much so.
Okay. Can you detail those expenses for me?
Okay. Her dues for volleyball are $1,800 for the fall season and $700 for the summer beach season. And then we travel to 9 tournaments, mostly in Houston, that are just one day, but there are 2 overnight out-of-state tournaments.
Okay. Mr. Edwards, is he exercising much visitation with the children?
No, sir. He has not seen the oldest daughter since July of 2021. And he saw the youngest one over the summer briefly, but he doesn't come here. He's only been here once in the last 12 years.
Okay.
Objection. I don't see what the relevance is for the questions about visitation.
Do you have a question, Mr. Elrod?
Of course, they're
All right,
listed in.
guys. The hearing now turns toward the children's real-world expenses, and the testimony becomes far more detailed. The mother explains that their oldest daughter remains enrolled in a specialized dual enrollment program, allowing her to complete high school while simultaneously attending college. Although tuition is covered through the program, she tells the court that the family must still pay for housing, meals, books, mandatory fees, and other educational costs. Those ongoing obligations, she argues, place a significant financial responsibility on the household despite the academic scholarship. The attorney carefully breaks down those expenses for the judge. The mother explains that the family spends roughly $10,000 each year to keep their daughter enrolled in the program. Even with scholarships reducing part of the overall cost, thousands of dollars remain unpaid each semester. She also explains that transportation costs continue because their daughter drives home on weekends, requiring insurance, fuel, and vehicle maintenance. According to her testimony, these educational commitments represent investments that were made while both parents enjoyed a much higher combined household income. Attention then shifts to the younger daughter, Cameron, whose competitive volleyball schedule introduces another layer of financial responsibility. The mother explains that Cameron has participated in club volleyball for several years, a commitment involving substantial registration fees, seasonal dues, uniforms, equipment, and extensive travel. She tells the court that tournaments frequently require trips across Texas, with some events even involving overnight stays outside the state. These recurring expenses, she argues, are far beyond the ordinary costs of raising a teenager and continue throughout each competitive season. But then the discussion takes an emotional turn. The attorney questions how often the father actually exercises visitation with the children. The mother testifies that contact has been extremely limited, claiming the oldest daughter has not seen him in years while the younger daughter has visited only briefly. She further explains that because the children spend nearly all of their time with her, she shoulders almost every day-to-day expense without extended breaks. Although the father objects to the relevance of these questions, the judge allows the testimony to remain part of the record.
Of course, they're listed in Chapter 154.123 as additional factors the court can consider.
Your objection's overruled, Mr. McNulty.
In that he doesn't exercise much visitation, does that mean the kids are with you the vast majority of the time?
99%.
Much more so than somebody who exercises, say, a standard possession schedule.
Right.
So you don't have a period of time, whether it's every other weekend or on spring break or holidays or the summer, where you're not having to pay for the kids' basic care or whatever while they're in your possession.
Right.
So ultimately that leaves more day-to-day expense for you.
Yes, sir.
Okay. Do you believe at this point in time Mr. Edwards is underemployed given in respect to his duties to his children?
Absolutely. Since December,
Okay.
January.
Are you expecting him to stay unemployed?
I fully feel like he will find another job. He's only 50 years old and able-bodied.
Okay.
So I think government contractor jobs or consulting jobs or whatever are usually what happens after retirement from a federal agency.
Is there any other reason that you're aware of why the court should deviate from the guideline child support amount?
I feel like doing this to them after their entire lives having a lifestyle that met the lifestyle we had when we were married would be detrimental to them in their future.
And they have some additional expenses that may not occur for every child. Is that correct?
Yes, sir.
But it's stuff they've been engaged in.
Right. And
Okay.
stuff, if we were still married with our salaries, they would probably continue. They would probably have these same opportunities.
Okay. When the kids, is he responsible for 50% of the uninsured medical expense?
On paper, yes, sir.
Does he typically?
Mr. Elrod, you don't have any pleadings on file for that.
Okay.
So let's not get into stuff we don't have pleadings on file for.
Yes, Your Honor. I will pass the witness.
Your witness, Mr. McNulty.
No further questions from the state.
Mr. McNulty, do you have any additional witnesses not sworn?
I have no
Can
other
I ask-
witnesses, Your Honor.
Well, stop, Mr. Edwards. There's a process to trial.
I'm
You're
sorry, sir.
unrepresented, but I'm still treating you like a lawyer. That means you have to act like a lawyer. You wait for your turn. I'll give you your turn, okay? The state gets to go first, and then Mr. Elrod gets to go second, and then you get to go third. All right?
I'm sorry.
Mr. McNulty, do you have any other witnesses?
No other witnesses, Your Honor. The state rests.
All right, Mr. Elrod, your turn. Do you have any additional witnesses that you wish to call?
No, Your Honor, I don't.
All right. Now, Mr. Edwards, see, I'm an old school judge, Mr. Edwards, and I believe in using the rules of civil procedure the way they were intended.
I understand, sir, and I apologize
Do you have any additional, Mr. Edwards, any information you think I need to know about this case before I make a ruling?
I would just like to, am I allowed to ask Miss Langley any questions? And
You may.
Thank you, sir. Would Miss Langley, let's speaking to the visitation, when we were initially divorced, how far apart did we live?
We lived 200 miles.
Okay, so a weekend visitation, et cetera, was possible.
Yes, sir.
And did that happen when we initially were divorced?
For the first year.
Okay, and what changed that visitation schedule?
I moved.
Okay, and how far away from me did you move at that time?
All right, guys. The courtroom tension reaches another level as the attorney argues that the father's limited visitation directly affects the financial burden carried by the children's mother. She explains that because the children spend nearly all of their time in her care, she covers the overwhelming majority of their daily living expenses, including food, transportation, clothing, school activities, and countless routine costs. She goes even further, telling the court she believes the father is currently underemployed and fully capable of securing another job despite choosing retirement at only 50 years old. The attorney then asks whether there are any additional reasons the court should reject the standard child support guidelines. The mother responds that reducing support after the children have spent their entire lives enjoying a stable standard of living would be unfair and potentially damaging to their future opportunities. She reminds the court that both daughters have developed educational and extracurricular commitments that were made possible during the marriage. Before questioning expands into uninsured medical expenses, the judge steps in, limiting testimony to matters properly before the court and bringing her examination to a close. With the other witnesses finished, the judge finally gives the father an opportunity to present his own questions. Because he is representing himself, the judge reminds him that courtroom procedure must still be followed even without an attorney. After apologizing for interrupting earlier, the father begins questioning the children's mother about their visitation history. His strategy is clear. He wants the court to understand that circumstances surrounding contact with his children changed dramatically after the divorce, particularly because of the increasing distance between their homes over the years. The father asks the mother to confirm that, immediately after the divorce, they lived only about 200 miles apart, making weekend visitation practical and consistent. She agrees that regular visitation initially occurred before later circumstances changed. He then asks what caused those visits to become much more difficult, and she acknowledges moving approximately 800 miles away. While she insists they still made efforts to arrange visits by plane and long-distance travel. The father highlights how that relocation significantly reduced the opportunities for frequent in-person contact with his children.
I'm sorry, it cut out. I couldn't hear the response.
800 miles.
800 miles. So at that point, was visitation more difficult?
It was, but we still did it. We flew back and forth on a plane until Cameron turned old enough to fly by herself.
Okay,
Okay, go ahead. Sorry.
And how often per year did that happen?
We probably flew the kids back and forth 3 or 4 times, and I drove to West Texas and to New Mexico to where you live to bring them to you multiple times a year.
So you would say that it definitely decreased based on the distance?
Yes,
Okay.
but not the way it is now.
Has Kieran been given the option to visit me in the last 2 years that you said I have not seen her?
Judge, I'm going to object to the relevance, the
Oh,
point.
no, you brought this up, Mr. Elrod. He gets to ask questions to defend himself.
I have no idea because you do not communicate with me. You only communicate with my daughter. So I don't know if you've given her the option or not.
Good answer.
I know I've bought one plane ticket 2 times since July 21. You've seen Cameron 2 more times, and I bought 2 plane tickets.
So you and I have not communicated that I would not force her to come visit me, that I would ask her, but I would not force her to come visit me. We have not communicated that.
You did communicate that you were not going to force her, but I have no idea if you did or not. I just know your wife wanted to buy 1 plane ticket.
How many family cars do y'all have?
We have 3.
Okay.
1 for each of us.
What is the newest vehicle in your family?
Mr. Edwards, I don't need to hear what y'all's expenses are.
Okay.
Child support in Texas is real simple.
Thank you, Your Honor.
Those were good questions. Those were good questions, Mr. Ed.
Thank you, sir. I appreciate
about the visitation. Those were good questions.
I appreciate your time, sir. I don't have anything.
Mr. Edwards, now I want to ask you, you're unrepresented. I need to know, do you have any information that you think I need to know about this case before I make a ruling?
Just this, sir. I've always paid my obligations. I served 20 years to defend my country. I'm not trying to shortchange my children, but right now I just got paid my first payment. It was $2,400.
Right.
So I have $100 to live on, sir. So I can't afford.
Well, no, Mr. Edwards, let's be honest about something. You don't have $100 to live on. You got $25,000 to live on, because that's what you pulled out at the end of your stuff. That's additional income.
I want to tell you though that I didn't pull it. That was just
you got paid that.
Correct. To live on 8 months before they start paying me fully, sir.
I don't know what you did with the money, Mr. Edwards, but that's income. And it should have been factored in when this was done, and it wasn't.
But it's not income. It's only one. I mean, it's a one lump sum. It will never show up again.
Mr. Edwards.
Yes, sir.
See, I'm in the business of history, not in the business of future prediction. All of the information that Mr. Elrod was able to glean and give to me, all of the information that you were able to glean and give to me is all great information. The problem is I can't guess what your income is going to be in the future. While I understand what Miss Langley says, that you are capable of going out and getting a job, and you could do that. I can't force you to do that. You had a right.
All right, guys. The father's questioning continues as he shifts attention to his relationship with his oldest daughter. He asks whether she had been given opportunities to visit him during the previous 2 years. The mother responds that communication between them has been extremely limited, explaining that she and the father rarely communicate directly anymore. She recalls that airline tickets had been purchased on more than one occasion and maintains that she never forced their daughter to travel against her wishes. The exchange highlights how communication problems have complicated an already difficult family situation. The discussion briefly moves toward the mother's household, with the father attempting to ask questions about family vehicles and financial circumstances. Before the conversation can expand, the judge interrupts and explains that those details are not central to deciding the child support calculation. He reminds everyone that Texas child support law is designed to focus primarily on income rather than every household expense. The judge compliments the father's visitation-related questions, but redirects the hearing back to the issues that will actually influence the court's final decision. The judge then gives the father one final opportunity to address the court directly before a ruling is made. Speaking sincerely, the father explains that he has always honored his financial responsibilities and proudly served his country for more than 20 years. He tells the judge that after receiving his first retirement payment, very little money remained once his existing child support obligation was deducted. The judge, however, points out that the father also received a lump sum retirement payment of approximately $25,000, reminding him that this money cannot simply be ignored. But here's where everything changes. The judge carefully explains that although the lump sum payment was received only once, it still qualifies as income for purposes of evaluating the modification request. At the same time, he recognizes that the father's retirement caused a genuine reduction in monthly earnings and that the court cannot simply assume he will obtain another job in the future. While acknowledging the mother's concerns about future employment opportunities, The judge emphasizes that decisions must be based on verified financial facts rather than speculation about what might happen later.
You had a right to retire under the terms and conditions of the federal retirement system, and you did that. That is your right. And so that was a huge decrease in your income. But you got $25,000 additional dollars when you retired. And that was not factored in, and I'm going to factor it in because it's income. At some point in time, you're going to have to declare it, and you're going to have to pay taxes on it. Okay? Because that's how it works.
Okay. Can I ask one question? I understand your point, sir. Can I ask one question?
Sure.
So when next year, when that income is no longer part of my income, do I do this process again?
You can. If it's going to reduce your child support by more than 20% or $100, you can. You can ask for another modification. And of course, Mr. Elrod and his client are going to be able to take and see, hey, did Mr. Edwards go out and get a job, or is he just still sitting at home and still just making his $6,000 a month? You know, that's their right too, right?
Yes, Your Honor. Thank you.
Child support is going to be adjusted to $1,500 a month effective March the 1st. Father's going to be ordered to carry the health insurance in the middle.
Sir?
Yes.
That we can't be that effective January 1st when my income changed, sir?
No, I can't. I'm not allowed to do that. Law doesn't allow me to do that.
Yes, sir.
So I'm doing March the 1st because that's at least most of the month. So at least it'll go back and pick up 1 month for you. They just filed it in November, Mr. Edwards, and I got a ruling on this case in 90 days. If you think you can find a court that's faster than that, you let me know. I'm not aware of any district courts that allow you to do child support modifications at least 6 months, but Mr. Elrod will tell me if I'm incorrect.
I think you're
That's
on the
pretty
money.
fast. That's pretty efficient. That's one thing I do pride myself on, is trying to get these cases moved fast. All right. This is what's going to happen now, y'all. The state's going to adjust this child support order that they sent into the court. If it matches what I said here today, I'm going to sign it, get it back to them. They're going to make a copy of it, send it to each of you. Now, if Mr. Elrod plainly knows, and Mr. Edwards does not, any party has the right to appeal my decision. If you wish to appeal, your appeal has to be in writing. It has to be filed in the next 3 business days in the Tyler County District Clerk's office. You're also responsible for making sure you send a copy of that written appeal to all the other non-appealing parties. Now, you don't know when I'm going to sign the order. It might take a few days for that to happen. They're generally pretty efficient about getting it to me, but you don't know specifically when your start date is going to run if you wish to appeal on the 3 days. My suggestion is you get the appeal in immediately, and that way you don't have to worry about it. It's a complicated case. This is not a straightforward, easy, this is what he makes, this is what he pays kind of case. There's lots of extenuating circumstances that go along with it. If y'all think the district judge can do a better job than I did, you are welcome to do so, and I will not be offended of that, I promise. Okay? Mr. Elrod, do you wish to review and sign the order?
Yes, Your Honor.
All right. So they'll make sure they send it to you, Mr. Elrod, to review and sign as an attorney of record in the case. Okay? All right.
Thank you, Judge.
Everybody should get a copy here shortly, though. Like I say, they're pretty good about getting them to me pretty fast. I appreciate y'all. Y'all did a wonderful job. You did a wonderful job, Mr. Edwards, of presenting your case and giving me the facts that you have for them. So, and I do appreciate y'all's patience, and I appreciate that y'all giving each other time to get the information out that you think I needed to hear.
So he doesn't owe me child support?
Not after May 21st, not after May of 2021, he doesn't. Whatever he owed you.
Still have Matthew.
Well, that's what I'm saying. The court order, the way this court order is written, he's not ordered to pay you child support for that child.
All right, guys. The hearing reaches its defining moment as the father asks whether he can request another modification once the one-time retirement payment is no longer part of his financial picture. The judge explains that if his circumstances change enough to meet the legal requirements, he is free to return and seek another review. However, the court also makes it clear that the children's mother would have every right to present evidence, showing whether he found new employment or continued relying solely on retirement income before any future adjustment could be considered. After weighing every argument presented throughout the hearing, the judge delivers his ruling. Instead of granting the full reduction requested, he orders the monthly child support obligation to be reduced from $2,300 to $1,500 beginning March 1st. He also requires the father to continue providing health and dental insurance for both children. When the father asks if the modification can be made retroactive to the date of his retirement, the judge explains that Texas law does not permit that adjustment under the circumstances, making March 1st the earliest effective date. The judge then outlines what will happen next in the legal process. He explains that the state will prepare a revised child support order reflecting everything announced in court. Once reviewed and signed, copies will be provided to both parties. The judge also reminds everyone that either side has the legal right to appeal the decision, but any appeal must be filed in writing within the required deadline. He notes that while no ruling satisfies everyone, the legal process exists to ensure each party has an opportunity to challenge the outcome if necessary. As the hearing comes to a close, the judge thanks both sides for remaining respectful throughout a difficult and emotional case. He specifically acknowledges the father's effort in representing himself and presenting his arguments without legal counsel, while also recognizing the mother's testimony regarding the children's ongoing needs. In the final moments, one last point is raised concerning child support after the oldest child reaches adulthood, reminding everyone that future legal obligations may change as circumstances evolve. With that, the courtroom session concludes, bringing an end to a complex dispute over retirement, parental responsibility, and the financial future of two children.